Hello, everybody, and welcome to History Bite number 85, dated October 17th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled The Court of Appeals of Maryland. In Maryland, the Court of Appeals is our highest court. It is our Supreme Court, and as the highest judicial tribunal in the state, it typically has the final say on the interpretation and meaning of Maryland law. Its decisions are only reviewable by the Supreme Court of the United States under the appropriate circumstances. The Court of Appeals has a deeply rooted and very long history in the state of Maryland, with its origins going back to the late 17th century when Maryland was, of course, still a British colony. The Court of Appeals in form and function today, however, owes its existence to the Maryland State Constitution of 1776, our original state constitution. The court consists of 7 judges, each of whom come from one of the state's 7 appellate judicial circuits. These judges are appointed by the governor of Maryland and must be confirmed by the state senate. Upon confirmation, they go on to serve 10-year terms in office. Like the Court of Special Appeals, Court of Appeals judges, in order to remain in office and continue to serve 10-year terms, until retirement that is, they must win re-election by way of non-contested retention elections, all right, where the citizens of their appellate judicial circuit must vote a majority yes for the judge to remain in office, all right? If a majority of citizens vote no, or if the vote is tied, then the judge must leave office. But in my lifetime, I have never known that to occur. So, in almost all circumstances, the incumbent judge will be retained in office with a majority of yes votes, as they cannot be challenged by any outsiders, like on the circuit court, and the judge will continue to renew their 10-year terms by way of retention until they retire at either 70 or before, all right? And of course, if they stay until 70, they can always be recalled on a per diem basis, and that happens a lot at the Court of Appeals level, all right? So they collect their pension and receive their per diem pay as well once they retire and they are recalled, all right? So the Court of Appeals has a chief judge who is designated to that position by the governor. The Maryland State Constitution requires that one of the judges be appointed as the chief judge. So in Maryland, our chief judge has to be an in-house appointment. The governor must designate one of the judges of the Court of Appeals as its chief judge, okay? And that is a position that they hold until they leave the court. The chief judge, for the record, is the constitutional administrative head of the Maryland judicial system. Okay? So, as the state's highest court, the Court of Appeals, all right, since at least the 1970s, has heard cases almost exclusively by way of certiorari, okay, a very discretionary review process, all right? Writ of certiorari, simply a writ to certify. They are certifying areas of law under dispute and in question, and the state's highest court thus needs to review and certify the area of law that is, confusing or muddled or, needs clarity, okay? So thus to certify and make clear, all right, the Court of Appeals will hear cases on a writ of certiorari from the Court of Special Appeals, from the circuit courts, okay, occasionally from the orphans courts and from the state's tax court, all right? The Court of Appeals obviously only accepts cases which are of incredible importance, okay, cases where the public interest is definitely at stake, where major issues are at stake. The court does not take minor minor, insignificant appeals. The vast majority of appeals don't present significant major league questions, all right? The Court of Appeals only takes cases that present major league, highly important questions, statutory or constitutional, that are in need of adjudication and finality, all right? So it is the duty of the Court of Special Appeals, immediately below the Court of Appeals, to weed out those appeals which are not, of significant gravity, and the Court of Appeals itself, either before or after adjudication by the Court of Special Appeals, or, sometimes straight from the Circuit Court, under rare instances, will decide cases on a writ of certiorari to them, all right? But make no mistake about it, all of the cases appealed to the Court of Appeals on a writ of certiorari from the Court of Special Appeals or from the Circuit Courts, all right, are of major league importance to the public interest in Maryland, all right? These are cases that, like I said, present very important questions that are in need of finality and total disposition by the state's highest court, all right? The Court of Appeals can also directly pull cases from the Circuit Courts or the Court of Special Appeals, without someone actually appealing it to the Court of Appeals. The court has that right to do that, and obviously only does that when the matter is of extreme, very pressing significance, all right? The Court of Appeals also is empowered to hear certain cases exclusively, all right, under Maryland law. And those areas are legislative redistricting, removal of certain civil officers, as well as certifications of questions of law, okay? So in sum, the Court of Appeals deals with the most important legal issues in the state, legal cases and controversies, all right? The Court of Appeals does not deal with minor things. That is for the inferior courts to deal with, all right? By the time it gets to the Court of Appeals level, it is obviously something that has significant weight to it and is in need of adjudication by the state's highest court, all right? So, with all that said, the Court of Appeals also has administrative functions, including the regulation of the practice of law in the state of Maryland. It also adopts rules on judicial administration, procedure, and practice, and these rules are, of course, binding, all right? Like I said, regulating the practice of law, it admits people to the practice of law, okay, per the recommendation of the Board of Law Examiners, and it also conducts disciplinary proceedings involving members of both the bar and the bench, okay? Like I said, the Court of Appeals has 7 judges, all right? And at least 4 of those judges, when they render a decision on a case, must agree in order to form a majority opinion, okay? With that said, when one argues in front of the Court of Appeals of Maryland, all right, it adheres to traditional appellate practices and procedures, all right? You are one of the attorneys, and before court begins, all right, you will hear promptly the court crier at 10 a.m. Before arguments begin, they will say, "All rise." And as the judges enter the courtroom, the court crier will say, "Oh yea, oh yea, oh yea, all persons having any business with the Honorable Court of Appeals of Maryland, draw near and give your attention. The court is now in session. God save the state and this honorable court. Please be seated." And after that, the judges will sit down. The court crier will place the gavel before the chief judge, and oral arguments will begin. All right, and the court will, of course, hear its docket for the day. All right, like any other appellate court, the Court of Appeals is filled with intelligent, very broad-thinking jurists who put intense work and effort into their decisions. They do not always agree, and they should not always agree. Okay. But each decision rendered from the Maryland Court of Appeals is very well thought out and has the future and security of the state in mind. All right. I myself have had the pleasure of sitting on the bench of the Court of Appeals of Maryland back in November of 2008. when after a meeting with then Chief Judge Robert M. Bell, I asked him if I could see the courtroom. And then once in there, I asked him, could I sit on the Court of Appeals bench? And he was all too happy to oblige. And of course, I sat in his chair, and was just in seventh heaven for that moment, as that was my career ambition at the time, to become Chief Judge of the Court of Appeals of Maryland. And a couple of pictures were taken to prove that, if anyone doesn't believe me. Okay, so yes, the Court of Appeals is a very, very, very old institution in the state of Maryland and has certainly influenced the development of Maryland law over the past 2.5 centuries. All right. So, in conclusion, the Court of Appeals, as the state's highest court, considers and disposes of matters that are of most pressing statutory and constitutional significance to the state. All right? Hearing only things which have long-term importance or are in most immediate need of resolution and finality, something that can only officially be done by the state's highest court. All right? And like the Court of Special Appeals, by the way, they meet in the same building. All right? The Court of Appeals and the Court of Special Appeals both sit in Annapolis in the Robert C. Murphy Courts of Appeal building on Rowley Boulevard in Annapolis, Maryland. All right? So I think that about covers it all. If you have any questions, controversies, please feel free to leave them down below, and I'll be happy to answer them. Thank you for listening to this History Bite about the Court of Appeals of Maryland, our state Supreme Court. And I hope to talk to you at the next History Bite. Take care, stay safe out there, and peace.